Perhaps one of the most important subjects in the major area CDI, or crime detection and investigation, is the police operations and planning with crime mapping. I say one of the most important simply because when you graduate and you will apply in the Philippine National Police, the guidelines and the principles incorporated in the discussion of this subject will be the same guidelines and principles while you perform your police duties. So what we are going to do is we will be dividing the discussion in this subject into two. The first episode will center on police basic operations, mainly on arrest, search and seizure, as well as on the guidelines in the conduct of checkpoint. While on the second episode, we will be tackling about the remaining topics, the remaining police basic operations, as well as police planning and crime mapping, which is also important in dealing with criminality in the society, or in suppressing or controlling crime inside the society. Let us start the discussion by taking a look on the nature of a police office. So, a police officer is a public servant. So, when we say public servant, the main responsibility of the police officer is to serve and to protect the community. So, it is not only limited on serving or protecting the community, but also police officers are entailed to perform non-law enforcement related activities. Like say for example, like assistance during calamities, or assistance in traffic, or even assistance in the pacification of domestic quarrels, as well as on other non-law enforcement duties that may somehow, win the trust and the confidence of the people. By doing non-law enforcement related activities, this may boost cooperation or coordination or collaboration between the community and the Philippine National Police Agency. Because without the trust, without the confidence coming from the community, the goal or the mission of the police agency in the maintenance of peace and order will become a failure. Because in everything that the police officer does, it should be something that would amplify public trust. If there is public apathy on the part of the community, when I say public apathy, there is the loss of trust coming from the community, all of the goals and visions of the Philippine National Police will become a failure. So it is very important that the confidence and the trust should be won coming from the community, and the police officers should serve and protect with integrity, with moral ascendancy, with honesty, and with pure or selfless service. On the other hand, the Philippine National Police is considered as national in scope, as embedded in one of the provisions of Republic Act 8551. So when we say national in scope, the PNP has the jurisdiction within the entire Philippine archipelago. So if you're a police officer and you come from, let us say, you come from Negros Oriental, when you go to Luzon or when you go to Mindanao, your authority as a police officer remains. If you are a Tagalog police officer, you come from Luzon and you go to, let us say, Cebu, or you go to Mindanao, your responsibility or your duties or your authority being a police officer remains. If you are a Mindanaoan kind of police officer and you go to the Visayas or to Luzon, again, your responsibility, your authority as a police officer remains. Simply because, again, the PNP or the Philippine National Police is national in scope. So wherever you will go, so long as you are a police officer, okay, as long as you are a police officer, that authority will remain as long as you are within the Philippine archipelago. But if you will go to other countries, of course, our laws will not extend to the other countries. So basically, if you will go to America or to any Asian countries, our or your duty as a police officer or your authority as a police officer will no longer be carried with you, considering that it shall only be limited within the territorial limits of our country. On the other hand, the Philippine National Police is also considered as civilian in character. The PNP is national in scope and also civilian in character. This is also embedded in one of the provisions of Republic Act 8551. So the Philippine National Police as an organization is not part of the military organization, although it retains some military attributes such as discipline. So when we say civilian in character, this may mean two things. Number one, the PNP does not belong to the military organization. The Philippine National Police is not part of the AFP or the Armed Forces of the Philippines, but rather PNP is under the Department of Interior and Local Government. Or number two, Philippine National Police has to adopt the character of being a civilian while in the performance of their police duties. What do you mean by adopting the character of being a civilian? This means that the police officer should be a resemblance of integrity or moral ascendancy while he's performing his task as a police officer. That's what civilian in character means. Now, there are two general functions of a police officer during or in operations. Number one is to serve and protect. The serving and the protecting shall be channeled to the public. Okay? The public where the lives and the property are present. Police officers should not be individuals who will protect the illegal activity of a particular person, group, or criminal syndicate. So the protection or the serving or the protection should be channeled towards the community, not to organizations or not to illegal or criminal syndicates and criminal organizations. It should be the community who will be the center of the serving and the protection coming from the Philippine National Police. So if a police officer during the operations will give protection to a particular criminal who committed the crime, then that is a failure on one of the functions of a police officer. On the other hand, during the operations, it is the responsibility of the police officer to observe human rights and dignity of person. Human rights and dignity of the person. So, if you will take a look on the Police Operational Procedure Manual, you can actually find out the step-by-step process or the guidelines in the performance of a particular operation. And these guidelines or these processes are built in such a way that it respects the human rights or the dignity of the accused or the suspect. So, at all times, in any type of operations, every single police officer should be entailed to observe the human rights or the dignity of any persons involved in the operations. Now, the operations in the Philippine National Police are mainly categorized into 7. Okay? So, there are so many operations as enumerated in the Police Operational Procedure, and these operations are grouped or categorized into 7 categories. The first one is public safety operation. So when I say public safety operation, this involves activities at the PNP which are centered in the promotion of public safety. So basically, these are non-law enforcement duties. Like for example, fire drills, earthquake drills, rescue, search and retrieval, and other types of operations that are non-law enforcement in nature are under the first category. The second category is law enforcement operation. So when we say law enforcement operation, this involves the enforcement of our ordinances, the enforcement of our existing laws, the enforcement of our statutes and executive orders. As long as the activity involves the implementation of the law, it will form part under the second category. The third category is internal security operation. So the difference between internal security operation and the former categories is that in this operation, the activities are centered in ensuring internal security, not just in the Philippine National Police, but also in the country in general. So the purpose is to secure the country or to secure the community. So internal security operation usually involves about insurgency or counterterrorism. Like say for example, you want to suppress the rebellion activities of the New People's Army. So that is an example of internal security operation. Or you suppress the terrorist activities in Marawi City. That is also an example of internal security operation. If a particular activity involves a group of police officers who are trained on that activity, then that activity shall be considered as special police operation. Special in a sense that, again, the police officers that are involved in these operations are those with specialized training. I repeat, special in a sense that the police officers that are involved in these operations are those with specialized training. For example, hostage situation and you utilize Special Action Force. You utilize Special Action Force simply because PNP staff are specialized in terms of hostage situation. So again, this activity belongs to the fourth pillar of police, the fourth category of police operations. The fifth one is about gathering of information. If a police officer conducts an activity and the purpose of the activity is to gather intelligence information, like you conduct tailing or shadowing, you conduct surveillance, you conduct intelligence assessment or research, these activities will form part under the 5 category. How about undercover assignment? If the purpose of the undercover assignment is to gather information, okay, to gather information to secure or to make the community safe, then the undercover assignment shall be part under the 5th category, which is intelligence operation. The 6th category is investigation operation. So any activity that is investigative in nature, like you investigate a murder case, you investigate a homicide case, that is part under the 6th category, which is investigation operation. But take note, cadets, under investigation operation, the determination of facts and circumstances or the gathering of evidences can be done for the purpose also for the filing of administrative cases. Let's say, for example, there are erring police officers, okay, or police officers on a wall or absence without official leave. So if a particular person in the PNP will gather evidences to prove that his colleague committed a wall while in the performance of the duty, again, that will still be part of the 6th category. So again, the investigation could be criminal or administrative in nature. Criminal if it involves a particular suspect of a crime. Administrative if a particular police officer committed misconduct or malfeasance or nonfeasance while in the performance of the duty. The consequence of a criminal case is imprisonment, while the consequence of an administrative case is the removal or the termination of a particular employee from the PNP or from any government agency. The last category of police operation is scene of the crime operation or the SOCO. So we have the PNP SOCO right now, whose functions revolve in the processing of the crime scene. They do not only process the crime scene, but they also has the responsibility to do forensic examination or technical examination of evidences. Like say for example, there is a latent print coming from the crime scene. The latent print can be processed, can be subjected for forensic examination to find out who is the owner of the latent print. That is part of the responsibility under the seventh or the last category. If there is a particular blood spots found at the crime scene but there is no dead body left, so the blood spots could be subjected for laboratory examination, and that is again one of the activities under the seventh category. That is the responsibility of the PNP SOCO. So those are the categories of the operations in the PNP. But then again, cadets, there are so many operations in the police agency, but we will be concentrating only in this video. We will only be concentrating the basic ones. So again, we will be concentrating only on arrest, on search and seizure, on checkpoints, on patrol, and other basic operations. We will not be touching all of the operations because that will take us a lot of time in discussing. Okay? So, again, those are the seven categories of police operations. Take note that in every police operation that you will be doing, you have to follow, you have to accomplish the basic requirements. So what are the basic requirements? Number one, in the police operation, you need to use marked police vehicle. But we have exemptions. We have exemptions to this. If in case the police operation involves entrapment or buy-bust operation, it will be very impractical if you will use marked police vehicle, because the purpose of buy-bust operation is to arrest the criminal without his suspicion. And by using marked police vehicle, that may arouse suspicion on the part of the criminal. So again, if a particular nature of operation is not clandestine in nature, it should use marked police vehicle. Like say for example, checkpoint. In a checkpoint, there is a need for you to use marked police vehicle. In the execution of arrest, again, marked police vehicle should be used. But then again, during buy-bust operation, it would be very inappropriate. It would be very impractical for you to observe this requirement. Okay? The second one is, in the operation, it should be led by a police commission officer. So asa man gasugod ang police commission officer? Gasugod siya sa rangko nga police lieutenant, pataas. Okay? Police lieutenant pataas. Ang non-commissioned officers katong ubos nga rangko sa police lieutenant. Okay? Police master sergeant, police executive master sergeant, patrolman or patrolwoman, these are non-police commissioned officers. So in every operation, it should be at least led by police lieutenant or pwedeng police captain, basta kay police commissioned officer. The third requirement is with personnel in prescribed police uniform or attire. So, in the case of checkpoint, what is required for the personnel to wear would be the GOA. When I say GOA, I'm referring to the General Office uniform, the blue uniform. It is actually prohibited for police officers to be heterogeneous or to wear mixed uniforms during the conduct of police operations. Like say again, in the checkpoint, somebody might be wearing an athletic attire, somebody might be in a camouflage attire, somebody might be in a GOA. So these mixed uniforms may confuse the public. So again, the basic requirement is that there should be one uniform the same uniform during the conduct of operation. If it is GOA, then everyone should be in GOA. Everyone should be in a general office attire. Di kay ang usa ga athletic, ang usa ga camouflage, ang usa naka full battle gear attire, ang usa naka GOA. So maglibog, that will create confusion on the part of the public. But then again, as I have said a while ago, there are exemptions in the wearing of prescribed police uniform. Again, in buy-bust operation or entrapment, because this is a clandestine type of activity, it would be inappropriate or impractical for police officers to wear their general office uniform while they are doing, let us say, drug transactions. Because if there will be suspicion on the part of the criminal, the whole activity will become a failure. Di sa makakita ga buy-bust operation nga uniforme. Kita pa daan ang kriminal, di diretso na nagdalagan. Nganuman, na may pulis. So para dili mabantayan, dili mailan nga pulis ka, you should not be wearing a police uniform. That is an exemption. But for other operations, these three requirements should be strictly observed. Now, another topic that I want to emphasize is in the use of megaphones and similar instruments during PNP operations. In your screen, you can find the italicized sentence, the police shall not use warning shots during police intervention operations. That is very clear. Klaro pa nas adlaw nga klaro pa nas adlaw nga gasiga sa udtong tutok. Dili ka pwedeng mogamit og warning shots. Warning shots should not be allowed, okay? Warning shots are only seen at the movies or television, but it should not be practiced in real life. During actual intervention operations, the team leader shall use peaceful means, including the use of megaphones or any other similar instruments, or to warn or influence the offender or suspects to stop and or peacefully give up. For example, during checkpoints, and then somebody just barge in on the barrier that you placed or the warning sign that you placed at the midst of the roadway, then all you have to do is not to make a warning shot, but what you need to do is to use a peaceful means. What would be that peaceful means? You must have a megaphone, okay? A megaphone that will verbally warn the motorist, not shooting, okay? Because shooting or using your firearm in any police operation should only be done in accordance to the principle of self-defense. Okay? So if in case the motorist pull his firearm, shoot against you, then that's the time for you to pull your firearm or to pull the trigger. But if in case the motorist just drive from the signage, even though you instructed him to pull over, then what you will do is to use peaceful means. What you need to do is use megaphones. In the basic police operations, the most important or the most prevalent that is usually conducted is what we call arrest. Okay? Arrest is the mostly conducted type of operation in the PNP. So what is an arrest? Arrest is the taking of a person into custody in order that he may be bound to answer for the commission of an offense. So again, what is an arrest? Number one, the person is brought into custody. Okay? Number two, what is the purpose of taking into custody? That he may answer for the commission of an offense. Again, what is the purpose? Why he is brought into custody? The purpose is for him to answer the accusation of a particular commission of an offense. There are only two modes of arrest. It could be warranted arrest or arrest by virtue of a warrant or warrantless arrest. What's the difference between the two? The difference is that in warranted arrest, you arrested a person, you put him in custody because you have a warrant of arrest. Okay? You have the warrant. You execute the warrant. We call it as warranted arrest. But if you arrested a person and you do not have warrant with you, or you do not have the warrant in your possession, you call it as warrantless arrest. Warrantless arrest is also known as citizen's arrest. Why did you say, sir, nga pwede siyang tawagon og citizen's arrest? This is also called as citizen's arrest because anybody, even ordinary citizens, can perform warrantless arrest. Okay? We just have to follow the different grounds in the warrantless arrest and we can perform it. Okay? We can perform it as ordinary citizens. That is why warrantless arrest is also known as citizen's arrest. But usually, only a few persons in the community will perform this. Okay? As to the time of making an arrest, the execution of the arrest can be made anytime. Alright? It could be any day, or it could be during midnight, it could be early morning, or during daytime. As long as you want to execute the arrest, you can do it anytime. In the execution of the warrant of arrest, the head of the office to whom the warrant of arrest was delivered for execution shall cause the warrant to be executed within 10 days from its receipt. Within 10 days, the officer to whom it was assigned for execution shall make a report to the judge who issued the warrant. So this will answer the question with regards to the lifespan of the warrant of arrest. Take note that the warrant of arrest has no expiration. Okay? Let me be clear, cadets. There is no expiration of the warrant of arrest. The 10 days that is regulated in the provision of the law will only talk about the days or the number of days given to police officer to execute a report to the judge who issued the warrant. So if the police officer fails to execute the warrant because of a particular reason, he was not able to arrest the criminal or the suspect, after the lapse of 10 days, he will go to the judge who issued the warrant and he will make a report or will file a report. That's the purpose of the reglementary period. But it does not mean that the warrant of arrest will be expired. Again, warrant of arrest has no expiration. The 10 days that is stated on your screen will only refer to the days that is given to the police officer to execute the warrant, and if in case he cannot execute the warrant, he will file a report after the lapse of the period given to him by the judge. So there will be no expiration date of the warrant. Now, right now in the Philippine National Police, the PNP has to adopt the rules on the use of body-worn camera in the execution of warrant. Take note that this is the newest provision, the newest memorandum order or administrative order given by the Supreme Court to the Philippine National Police. And if in case the Philippine National Police will not follow these provisions or will not follow the order coming from the Supreme Court, there might be a big possibility that the police officer might be in contempt. Okay? So, it is very important that these new provisions or this new order will be followed regarding the body-worn cameras. So, in Administrative Memorandum number 21-06-08-SC by the Supreme Court, it states that during arrest, it is required to have at least one body-worn camera and one alternative recording device. A minimum of 2 devices to capture the events during the execution of the arrest. So again, the new provision right now or the new rule right now, which was not observed in the previous years of operations, is that right now there is a need for police officers to wear a body camera, okay? A body camera during the execution of the warrant. The execution of the warrant of arrest. How many body-worn cameras? At least 1. Plus an alternative recording device. It could be a cell phone, anything that will record. Anything that will record the video and the audio during the execution of the warrant of arrest or the execution of the arrest. Again, at least one body-worn camera, a camera that is attached to the body, that is body-worn camera, and the alternative recording device. It could be a cell phone or any kind of recording device. So how many devices should be used in the execution of the arrest? There are at least 2. If you want to use 3, 4, that is okay, but what is required will be at least 2. Now, if in case right now there is unavailability considering the fiscal status or the financial status of the PNP, police officers do not actually as of now have the body-worn camera. So the alternative would be, if in case there is unavailability, the officer can file a motion before the court to use alternative devices. Sir, niyong kasir nga naa naman lagi na alternative recording device sa unang paragraph. Naa na, pero again, ang gina-record diha, una, body-worn camera katong i-attach sa body. Ikaduha lang tong alternative recording device. A total of 2 devices. So if you do not have the body-worn camera, you can file a motion to the court in order for you to be given permission to use 2 alternative devices in replacement to the body-worn camera. So how many in total? Duha lang Japon. Unsay gamiton? Alternative devices. What would be these alternative devices are? It could be your cell phone, it could be anything, an equipment that could record the video and the audio during the execution of the warrant of arrest. Now, when making an arrest by virtue of the warrant, the officers wearing the body-worn camera shall notify the person to be arrested that the arrest is recorded. I repeat, during the arrest, there is a need for the police officer who is wearing the body-worn camera that he will notify the person to be arrested that a recording is going on, that a recording has been made. So take note, in the previous subjects, maybe you learn about the Miranda Rights. It has been stated that once you arrest the person, you have to not just recite people. You have to explain. You have to elaborate as much as possible. The Miranda Rights. You elaborate that he has the right to remain silent, and anything he will say can be used against him in court. You elaborate that he has the right to counsel, and if in case he cannot afford one, a lawyer coming from the public attorney's office can be provided to him. You elaborate that he has been arrested because of this particular nature of crime. Those are the Miranda Rights, okay, that you have to elaborate during the execution of the arrest. But since we have now the new administrative memo coming from the Supreme Court, it is much important that you do not elaborate only on the 3 Miranda Rights, but you also have to include the information or the notification about the recording during the arrest. So once you are done, like you would say you have been arrested because you are accused of the crime of murder. You have the right to remain silent. Anything that you will say can be used against you. You have the right to avail to a private lawyer. If in case you cannot afford one, a lawyer coming from the public attorney's office can be provided to you. And may I inform you that we are recording, or while we are doing the arrest, we are actually recording it live. We are recording the audio and the video. So again, you have to include the notification. You have to inform the person that you are doing the recording. Video and audio recording shall be activated upon arrival at the scene of the arrest. So meaning, you do not activate it while you are still at the police station. Okay? You do not activate it while you are still traveling. The regulation states that the activation, putting it on, shall be made when you arrive. Alright? When you arrive, not when you leave. It should be when you arrive at the scene of the arrest. Now, how about during warrantless arrest, sir? What will happen during the warrantless arrest? Does it need to follow the same regulation? The answer is yes. The arrest shall be recorded in the same manner. This is one of the challenges right now if the arrest will be performed by ordinary citizens. Okay? Let's say, for example, barangay tanod making the arrest. So this could be one of the complexities, one of the challenges that could be, a little bit, impractical if the person who will be making the arrest are those, barangay police officers or barangay tanods. So I think there is a need that the barangay tanods should also be aware about this new law on body-worn camera. But then again, the regulation remains that during warrantless arrest, there is still a need for the whole incident, for the whole execution to be recorded in the same manner with warranted arrest. Now, what will happen if there is a failure to observe the body-worn camera? What will happen if the police officer did not follow the regulation on the body-worn camera? So, if the police officer failed to observe the body-worn camera, it shall not render the arrest unlawful or the evidence inadmissible. So basically, it's okay. It is actually okay if you will not observe the body-worn camera. It will not make the arrest unlawful. It will not make the evidence inadmissible. Pero if officers who fail to use the body-worn camera has no justifiable reason, all right? There is no justifiable reason, or the police officer manipulate the recording of the body-worn camera, he will be liable for contempt of court. O, paperiso siya. Why? Mag-contempt of court man ka. So meaning, all right, it is okay if you will not use a body-worn camera, and the evidence will still be admissible, the arrest will still be lawful. But take note, if you do not have the justifiable reason, you do not have the reason that is considered as justifiable, you will be in contempt of court. Or if you will manipulate the recording, you shall still be again liable for the contempt of court. So, this could be an escape on the part of citizens or barangay tanods that will perform warrantless arrest. So, they may execute, let us say, warrantless arrest to a particular person, and they may file their justifiable reason to the court, explaining or elaborating as to why the barangay tanod failed to have the body-worn camera when he executed the warrantless arrest. So, persons not subject to arrest, immunity from arrest. So, this may appear to be a repetition to some of the topics in other subjects, but let us just review this. There are many persons, or some of the persons are actually immune from arrest. Let us say, for example, congressmen and senators. Congressmen and senators are actually representatives of of the public. So basically, once they are in session, they shall not be arrested. Okay, but we have to take a look on the grounds, all right, on the qualifications. Number one, the offense should not be more than 6 years. Okay, it should not be more than 6 years. Number two, the Congress or the Senate should be in session. Okay, so it should meet the two qualifications. If the offense is more than 6 years and the Congress is still in session, the person might be arrested. Or if the number of years is below 6 years, but the Congress is not in session, still that congressman or that congresswoman can still be arrested. So, here is the question. Can a senator or a congressman be arrested if he commits an offense not punishable for more than 6 years but not attending during session? This happened in the case of People of the Philippines versus Halosos, which was decided by the Supreme Court. According to the Supreme Court, the answer is no. In the case of the People of the Philippines versus Halosos, the court provides that as long as the Congress is in session, whether the incumbent congressman is attending or is absent therein, he shall be immune from arrest. Okay? So if again, the Congress is in session or the Senate is in session, even if the senator or the congressman does not attend in the session, considering that nakasession man ang Congress or ang Senate, dili siya pwedeng dakpon. Bahalag naara na siya siyang balay, ni absent ra siya dito sa Senate or sa Congress, pero in session man sila, so both ipasabot, dili Japon siya pwedeng dakpon. This happened in the case of people of the Philippines versus Halosos. So aside from congressmen and senators who are immune from arrest, sovereigns and head of state are also immune from arrest as provided by international law. They are immune from arrest as well as diplomatic personnel. Okay? As well as diplomatic personnel. These are diplomatic agents officially appointed by the government of a particular country or nation or state tasked to maintain international relations, like diplomats or ambassadors. So they are exempted from arrest. So again, during the arrest, it is very important that the Miranda rights should be elaborated. I say elaborated, not just recited, not just recited or memorized. It should be elaborated to the person who will be arrested. Again, there are 3 Miranda rights: the right to be informed of the cause and nature of accusation, like you inform the person about the cause why he has been arrested, the right to remain silent, and the right to counsel. Remember, cadets, that among the 3 Miranda rights, there is only one Miranda right that cannot be waived. Okay, there will be no waiver in this particular right. Okay, you can waive the right to remain silent. What do you mean, sir, by when you say you can waive? Pwede kang, for example, the right to remain silent, imong gi-waive ang imong right. Pwede ka nga mo istorya, pwede kang mo confess. So imong gi-waive imong right to remain silent. The right to counsel, ikaw ray ganahang mag-lawyer sa imong kaugalingon. Ikaw mo mahimong legal advisor or counsel sa imong kaugalingon. Pwede po nag-imong gi-waive imong kana nga right. Pero ang the right to be informed of the cause and nature of accusation, dili na pwede nimo nga gi-waive. Okay? It is not actually, this right cannot be waived. Alright? This right cannot be waived. You cannot say nga, sir, pwede dili lang ko nimo gi-inform kung anong gi-arrest ko nimo. Dili na siya pwedeng mahimo. Kinahanglan gyud nga gi-inform ka about the cause and nature of accusation. But you can waive other rights like the right to remain silent or the right to counsel. Again, cadets, take note again, and you have to remember this. Aside from elaborating these Miranda rights, you have to include the new regulation right now about the recording. You have to notify the person that the recording or a recording is ongoing while you are executing the arrest. Now, let us go now to arrest without a warrant. So we have grounds, right? We have grounds that we can utilize in the warrantless arrest. Okay? Number 1 is when in his presence or within your presence, the person to be arrested has committed, is actually committing, or is attempting to commit an offense. This is also termed as in flagrante delicto arrest. Now, in this rule, there are 2 requirements that must be present. Alright? There are 2 requirements that must be present. Number 1, the person to be arrested must execute an overt act. When I say overt act, katong makita. Okay? An overt act indicating that he has just committed, is actually committing, or is attempting to commit a crime. If the act is not overt, or it's not exhibited, alright, externally, like gahuna-huna lakang patyon ang tao, dili na siya overt act. So, dili siya pwede nga may mong basis sa arrest. Pero kung naay overt act, meaning nakita iyang gi-perform, indicating that he committed or is actually committing or is attempting to commit a crime, then that could be a basis for under the first ground. Number 2, the overt act is done in the presence or within the view of the arresting officer. Remember that it is not sufficient that the suspect exhibits unusual or strange acts or simply appears suspicious. Okay? It is not sufficient that the suspect appears to be suspicious. Its suspicion is not enough to prove or to say that the person should be arrested. Okay? Like say for example, galakaw ang tawo, naka-jacket, naigabuknol sa kilid, imong gi-arrest, kaya naman, paminaw nimo pusil to, kay suspicious lagi kuno. Dili pwede. Okay? Dili pwede. Again, there are two requirements that should be present. Number one, the person executed the overt act, indicating that he's actually committing or is attempting to commit a crime. And number two, the overt act should be done in your presence or within your view as the arresting officer. Now, I have a question. Here. As a police officer, how would you determine if the act is considered as an overt act of a crime in your presence that would justify a warrantless arrest in flagrante delicto? So, kung saan man yung pagkabalo nga ang usa ka act is considered as overt, okay? How would you know that a particular act is an overt act that would be or that would justify a warrantless arrest? So, if you will take a look or if you happen to read the decision of the Supreme Court in People of the Philippines versus Chua Ho San, the court held that the arresting officer must have personal knowledge of the facts. Right? Personal knowledge of the facts. As recent case law adverts to, personal knowledge of facts or circumstances convincingly indicative or constitutive of probable cause. This means that the act committed in the presence of the police officer can only initiate in flagrante delicto arrest once a probable cause exists. Okay, once there is a probable cause, and the probable cause is based on your knowledge. For example, a person took his knife, he drew his knife, and he is about to stab another guy. So the act of attempting to stab another guy is already a probable cause for you to execute an in flagrante arrest or a warrantless arrest. So again, the first ground is when in your presence, the person to be arrested has committed or is actually committing or is attempting to commit an offense. So this is a ground that you can perform warrantless arrest. This is also known as in flagrante delicto arrest. The second ground is when an offense has just been committed and he has probable cause to believe based on personal knowledge of facts or circumstances that the person to be arrested has committed it. This is also known as hot pursuit arrest. Okay? Hot pursuit arrest. So in your screen, you can find the sentence, the phrase has just been committed connotes immediacy. Okay? Immediacy. The measurement of immediacy is between the time the offense was committed and the time the arrest was made. Okay? Again, the measurement of immediacy is between the time the offense was committed and the time the arrest was made. Munang ginatawag sa hot pursuit arrest. Okay? Because after the person committed the crime, you pursue him. Okay? You pursue in order to execute an arrest. So for an arrest to meet the element of immediacy, there has to be a sense of urgency on the situation itself. For example, spotting a robbery scenario while you are patrol on beat. Okay, you spotted a robbery scenario. So spotting the robbery scenario requires urgency to respond. Okay. Ang alam mo ito pa ka dito sa korte para mga ugwaran. So, impractical na kayo. So, say a robbery situation, that will require urgency to respond. It would be too impractical if the police officer would leave the robbery crime scene then procure a warrant. Okay? So, in this case, hot pursuit arrest can be made or this warrantless arrest can be made. Now, the question right now is, how long is the time gap between the commission of an offense and the time of arrest for hot pursuit arrest to become valid? Okay? How long? This is a very legitimate question. Okay? This is a very legitimate question. How long is the time gap? The time gap between the commission of an offense, or when the offense was committed, and the time of arrest for a hot pursuit arrest to be considered as valid. So, according to the decision of the Supreme Court, it is stated that hot pursuit or hot pursuit arrest to become valid must be executed on the same day. Okay? On the same day. That is in accordance to the People of the Philippines versus Tonog. So, unsa may buot ipasabot ani, pananglitan, person A murdered or killed person B, and person A, the suspect, escaped from the crime scene. So, ikaw nga police officer, dapat pwede ka mohimo og hot pursuit arrest without the warrant, considering that the arrest should be made on the same day. But if you are planning to conduct the hot pursuit arrest, pagkaugma na on the other day na, dili na pwede. You have to procure a warrant na pagkaugma na. Kung above 24 hours na. So, hot pursuit to become valid should be made or should be executed on the same day. Alright? Or if possible, immediately after the offense has been committed. So, naigidunggab, automatic adto ka, dakpo nimo ang suspect. Okay? Dakpo nimo ang suspect. So again, when is hot pursuit arrest becomes invalid? Again, mahimo siyang invalid. Mahimo siyang invalid if executed 1 day after the crime was committed, or worse, 6 days after the commission of the crime. So kinahanglan na ka nga kung beyond 1 day na ang hot pursuit arrest, you need to procure a warrant. But if in case the crime happened on a particular time, and then you pursue the suspect in order to execute the arrest, that is okay, that is still valid, so long as it is within 24 hours. But if it is beyond already 24 hours, that's the time that you need to procure a warrant in order to execute the arrest. So I hope you understand the second ground. So the last ground is when the person to be arrested is a prisoner who has escaped from a penal establishment or place where he is serving final judgment, or is temporarily confined while his case is pending, or has escaped while being transferred from one confinement to another. So, escaped prisoner, once they go to the public or to the community, they can be arrested without a warrant. So there's no need to procure a warrant. Anybody could arrest a prisoner who escaped from any penal institution. The next topic is about custodial investigation. So custodial investigation shall include the practice of issuing an invitation to a person who is investigated in connection with an offense he is suspected to have committed without prejudice to the liability of inviting officer or any violation of law. So when you say custodial investigation, meaning the person is put into custody and is subject for questioning. So the issuing of an invitation, like you will say, Juan, may I invite you to be at the police station for questioning with regards to the commission of this particular crime. The invitation again is already qualified to be considered as custodial investigation. So during custodial investigation, again, you have to observe the Miranda Rights. It should be explained to the suspect, okay? So we have Republic Act 7438. What is Republic Act 7438? That is the law that enumerates the rights of the accused under custodial investigation. So please observe. You have to observe the rights of the accused as embodied under Republic Act 7438. Okay? The rights of the accused under custodial investigation. Now let us go now to the second police basic operation, search and seizure. So this is classified into two. First one is search and the other one is seizure. So we'll be explaining each one. So let us understand first what is search. Okay? What is search? Search is an infringement of an individual's reasonable expectation of privacy. Search here as applied to the enforcement connotes a different meaning. An inspection which does not intrude upon a legitimate expectation of privacy or compromise any legitimate interest in privacy is not considered as a search. So that is very clear, cadets. All right, that is very clear. So if in case a particular inspection activity, like you would like to inspect, okay, you would like to inspect a particular place, and the inspection or the process of inspection does not intrude privacy on a specific person, then that cannot be considered as a search. For example, there is no search. There is no search if a police officer is looking for evidence in an open field or in an open area outside a person's residence. Okay, there is no search. When I say search again, as applied to law enforcement, there should be an infringement of privacy. The word search in here is not a literal. It does not connote a literal meaning. Okay. Because when you say search in the dictionary, it simply means to look for something or to seek for something. But that is not the meaning of search if we will apply it in police operations. Because search in police operations would refer to anything that would infringe privacy on the part of the person. So if you will go to an open field or an open area and you look for an evidence in that open area, there is no search. There is no search also if a police officer is, let us say, attentively staring at an unknown bystander who is looking suspiciously on an expensive car. So, looking or examining a person in a considerable distance is not part of what we call as search. Okay? Pero, if a police officer will be looking for something like an evidence inside the house or residence or in any places where there can be reasonable privacy, then we have now the infringement of individual privacy. So therefore, that already constitutes search. Okay? So again, if there is already an infringement of privacy, like the police officer will go inside the house of the person or we go to the residence of the person to look for something, there is now what we call as police search. But if the police officer will just be looking for an evidence in an open area, there is no such thing as search. All right? Or it will not qualify as search. Next, let us define what is seizure. Seizure is the detention of an individual or her property and removing that property from the control of the citizen, or in effect, taking control of the individual. So basically, when you see seizure, you detain an individual, or you take his property, or you remove the property from the possession of the person, or by simply taking control of the individual. That could be under what we call as seizure. In searching a particular property or in searching inside a residence or a house or a building, we need search warrant because in Article 3 of the Bill of Rights in 1987 Constitution, the law is very firm that there should be no search unless there is a warrant. Okay? So once we do searches, there should be a warrant that is procured from the court. Okay? So what is a search warrant? A search warrant is an order in writing coming from a judge commanding a police officer to search a particular property described, okay, described in the warrant and bring it before the court. Take note, what the subject of the search should only be the property that are described, okay? If the property are not described in the warrant, it should not be taken unless that property is something that be considered as a fruit of the crime. Next, there are as the same as arrest, search also have two modes. One is search by virtue of a warrant, the other one is warrantless search. So warranted search could be done if you have the warrant in the possession. Warrantless search can be done if you do not have the warrant. But there are actually grounds that we can take a look into before we go to or before we can execute warrantless search. Under the law, the validity of a search warrant is 10 days. Okay? In the warrant of arrest, it also mentioned about 10 days. But the 10 days in the warrant of arrest and the 10 days in the search warrant are actually different. Okay? As I have said a while ago, warrant of arrest has no expiration. But search warrant at the opposite has expiration. Okay? Because the validity of the warrant is only 10 days. So if the police officer fails to execute within 10 days, automatically the warrant shall be considered as nullified and should not be executed beyond 10 days. So if it is executed within 10 days, then the police officer who execute the warrant should file a report. Okay? File a report to the court that issued the warrant. As to the time of making the search, in Section 9, Rule 126 of the Rules of Court, it clearly states, the warrant must direct that it be served in the daytime. It should be served during daytime. However, there is an exemption. An exemption is that if the police officer will execute an affidavit, okay? An affidavit that would explain, right? That would explain the impracticality if in case the search will be made at daytime. In that case, the search can be done during nighttime. Okay? It can be done during nighttime. If again the place ordered to be searched is something that would compromise the security of the police officer, so it can be done during nighttime. But in general rule or in general regulation, it should be served during daytime. Should you choose to serve it during nighttime, there should be an affidavit. So like arrest, there are also rules that should be observed during the execution of a search warrant. Again, in the administrative memorandum order coming from the Supreme Court, right now, or unlike before, there is now a need for police officers to use body-worn cameras in the execution of the search warrant. So, the provision states that during search, it is required to have at least one body-worn camera and one alternative recording device, a minimum of 2 devices to capture the event during the execution of the search. Okay? During the execution of the search, again, there should be at least, again, number 1, one body-worn camera. Number 2, an alternative recording device. So you can use a cell phone as a recording device. If in case there is unavailability, consider the financial status of the police agency, then the officer who will make the search should file a motion before the court. That motion should contain on the use or utilization of an alternative devices. So if you do not have the body-worn cameras, then you have to use at least 2 alternative devices. It could be cell phones or any recording device. When making a search by virtue of the warrant, the officers wearing the body-worn camera shall notify again the person or the occupants to be searched that the search is recorded. Okay? So unlike arrest, in arrest you will be mentioning about the Miranda Rights. Plus, the cascading or telling the person that you are doing the recording. But in the execution of the search warrant, you do not need to mention about the Miranda rights, but rather you just have to notify the occupants or the person to be searched that you are recording. Okay? You are recording the whole incident. The video and the audio recording shall be activated upon the arrival at the scene to be searched. It should not be activated before. It should be activated when police officers arrived at the scene to be searched. So what would be the effect of failure to observe the body-worn camera? Here is the difference between arrest and search. In arrest, if the police officer fails to wear a body-worn camera, the arrest will still be lawful. Okay? The evidence will still be admissible, considering that if the police officer have justifiable reason. But if in case it is about the execution of the search and the person fails to bring with him a body-worn camera and an alternative recording device, it shall render the obtained evidences inadmissible. So all evidences shall be considered as fruit of the poisonous tree. When I say fruit of the poisonous tree, these are evidences that are illegally obtained and are inadmissible in the court of law. So police officers who fail to use body-worn camera without justifiable reason or manipulate the recording shall be liable for the contempt of court. So, unlike arrest, if you do not have the body-worn camera, all of the evidences will be inadmissible. At the same time, if you do not have the justifiable reason or you manipulate the recording, still you will be liable for contempt of court, and there's a big possibility that you will be imprisoned. So those are the rules under the issuance of administrative memorandum order coming from the Supreme Court. So what are the properties to be seized? These are the properties. The subject of the offense. If the subject of the offense is about drugs, then you have to seize the drugs. The stolen or embezzled and other proceeds or fruit of the offense, used or intended to be used as the means of committing an offense, like firearm. Objects that are illegal per se. What do you mean by per se? By nature. Objects that are illegal by nature. For example, if the subject of the offense is firearms, but you happen to see a methamphetamine hydrochloride on top of the table or a shabu is illegal per se. So therefore, you can seize it, even though it is not described at the warrant. Now, in making a search, there is a witness rule. Okay? There should be witnesses. Search of a house, room, or any premise shall be made in the presence of the lawful occupant. Take note, ha? Lawful occupant thereof, or any member of his family, or in the absence of the latter. 2 witnesses of sufficient age and discretion residing in the same locality. You can actually utilize barangay officials. That would be very effective during the search. Do not utilize minors because minors are not on sufficient age and discretion. Now, during the search, once you obtain different or various evidences, you have to issue a property receipt. Okay? Asa man mo gi-issue ang property receipt? Asa man mo ni gihatag? Imo ning gihatag dito sa occupant. Okay? Imo nang gihatag sa lawful occupant. Of course, while you give the receipt, it should be in the presence of at least 2 witnesses of the same sufficient age and discretion who are residing in the same locality. So, leave a receipt in the place in which he found the seized property. So, those are the areas on how you will conduct warranted search. So, aside from the effects of the failure to observe the policy in terms of the body-worn camera and about the witness of search rule, we also have the grounds for valid warrantless search and seizure. So, like arrest, we also have warrantless search. So, the first one is warrantless search incidental to a lawful arrest. So, in Section 13, Rule 126, Rules of Court, it states that a person lawfully arrested may be searched for dangerous weapons or anything which may have been used or constitute proof in the commission of an offense without a search warrant. The reasons of this search are threefold. One, to confiscate weapons from the arrested person which the latter might use to harm the arresting officer. Like, say for example, if the person is carrying a knife or a firearm, that should be confiscated or that should be searched even without the virtue of the warrant. Secondly, to prevent the arrested person from destroying any evidence within his or her reach. For example, he is carrying with him a lighter, okay? A lighter is something that could destroy especially documentary evidence. So you have to confiscate it. Thirdly, to confiscate weapons that might be used as means of escaping. Like he has pliers. He has with him screwdrivers or any tools that would afford him to escape from the authorities. All of these should be confiscated and you do not need to have a warrant, a search warrant in order to make searches, okay? As long as the person has been lawfully arrested. But if in case the person is not lawfully arrested, like the person is just walking on the street and without any notification, the police officer just came and arrest the person without his expectation. If the arrest is unlawful, the search shall also be considered as unlawful. So you have to make sure first that you have the probable cause to arrest the person. And if there is a probable cause established, that becomes the warrantless search valid. The second one is on the search of evidence through plain view. Okay, this is very complex. All right, this is very complex because there are a lot of police officers who violated this principle, right? This principle of search. So, plain view simply means anything seen on plain sight or having visual on things that are readily observable. Okay? So, take note of the word plain sight. Plain sight. So, when you are taking or when you are looking or opening the compartment of a motor vehicle, anything that is inside the compartment is not part of the plain sight. Because when you say plain sight, you are just using your eyes to search. You are not using your hands in searching, but rather your eyes, all right? Your eyes in searching. That is what we call as plain sight. Okay? And in plain sight, you have visual on things that are observable. So if you will try to scan a cabinet, the contents of the cabinet, that contents are not evidences that are obtained through plain sight because you use your hands, you scan, you get out, you open the door of the cabinet, and that is something that is illegal if under number 2, okay, under the second guideline. So to understand what is plain view, let us go to the next slide. So in order to have admissibility of these evidences under the plain view doctrine, it has to conform first on the following elements, okay? And these elements should be remembered because once you will become a police officer, this may result to some complexities or challenges in the admissibility of evidence. A prior valid intrusion based on the valid warrantless arrest in which the police are legally present in the pursuit of their official duties like trespass to a building to execute warrantless search is not covered under plain view doctrine. I repeat, if you intrude based on warrantless arrest, like you pursue a criminal, okay? You pursue a criminal by virtue of warrantless arrest, and then you go inside the building, okay? you go inside the building. Trespassing inside the building would constitute the search to become invalid. Okay? That is no longer covered under the plain view doctrine. Okay? Number 2, the evidence was inadvertently discovered by the police who have the right to be where they are. Okay? So when we say inadvertently discovered by the police who have the right to be aware, who have the right to be where they are, this means that the particular evidence is just placed on top of a particular place without any manipulation. You just found it there. Like when you get inside the room, you can see a methamphetamine hydrochloride or the shabu placed on top of the table. So that will qualify the second guideline. Okay? Inadvertently discovered by the police. So to understand it more, when we say inadvertence, it means that the police officers conducting the search must bear no knowledge that the evidence was present in the place, and that upon execution of search, such was accidentally discovered. This implies that an evidence that is inadvertently discovered is coincidental and without foresight. Again, you have a search warrant, and the inside of a search warrant, what is described is the confiscation of illegal firearms. But when you get inside the room, it so happened that there is a shabu placed on top of the table, and that shabu is not even described. Okay, not even described in the warrant. Still, you have the authority to take it simply because it is found in advertence. Okay, it is found in plain sight, and you can use it as evidence against the suspect. Okay, you can use it as evidence against the suspect. But if in case the subject of the search are illegal firearms, okay, are illegal firearms, and you are like a scavenger, like opening the different compartments or cabinets inside the room, and when you open the compartments of the cabinet, it so happened that you found a shabu. The question right now is, the shabu can be used as evidence in the court? The answer is no. Why? Because the shabu was obtained not in a plain view doctrine. Okay? So I provided you examples as you can see on your screen. For example, a firearm on the table, a drug paraphernalia on the floor, or within the principle of plain view. On the other hand, concealed contrabands inside a vehicle's compartment or inside the suspect's locker are likely not plain view. Okay? This usually happened during checkpoint. Like say for example, when a police officer during checkpoint will be the one to open the compartment or the U-box of a motorcycle, and it so happened that upon opening, he found a firearm inside the U-box. The question right now is, can he use the firearm as evidence against the driver? The answer is no. Why? Simply because, number one, he has no search warrant. Number two, he did not follow the plain view doctrine during checkpoint. Supposedly during checkpoint, it should be within plain view. It is plainly stated in the guidelines in the conduct of the checkpoint that there should be no opening of any compartment of a motor vehicle or any vehicle in that matter. Okay? So when you open a U-box, you open any compartment, and you find a contraband, still that contraband cannot be used as evidence because it is not in accordance to the plain view doctrine. The next ground is on the search to a moving vehicle. A warrantless search of a moving vehicle is justified on the ground that is not practicable to secure a warrant because the vehicle can be quickly moved out of the locality or jurisdiction in which the warrant must be sought. So in this case, if there is a moving vehicle and you found out that that moving vehicle contains a driver or a passenger who just committed an offense, you can actually make a search, okay? You can actually make a search without a warrant. But then again, we have to remember that in the search to a moving vehicle, there should be a probable cause, all right? There should be a probable cause to believe that the person or the passenger inside that vehicle has just committed an offense, okay? So you do not need to have a search warrant on this case. On the other hand, the other ground is consented warrantless search, or you consent on the search without the warrant. So consented warrantless search refers to the act of relinquishing or abandoning the right against search. However, it must be seen that the consent to the search was voluntary. So in Rule 17, Section 9 of the Rules of Court, it states that it is fundamental that to constitute a waiver of the constitutional right, it must appear that number one, the right exists. The second one is the person involved had knowledge, either actual or constructive, of the existence of such right, and the said person had an actual intention to relinquish the right. So if the particular warrantless search is consented, but the consent was done involuntarily, then the search shall be considered as invalid. For example, there are news everywhere right now, posted in Facebook and other social media, that police officers during checkpoint will do frisk search, okay? Will perform or execute frisk search. The frisk search that they perform can only be considered as valid as long as the person to be searched has consent or voluntarily submit to the warrantless search. But if in case the person will not submit to the search, and still the police officer will force the person to undergo a frisk search, then that is something that should be considered as illegal. Okay? That should be something that be considered as illegal. And when you graduate and you will apply in the Philippine National Police, you have to take note also that in the consented warrantless search, you should be meticulous in using this one, because the intimidation of the police figure may something that will cloud or may diminish voluntariness. Okay, I repeat, the intimidation of being a police officer carrying with you a .45 caliber firearm, whatever firearm you are carrying, is something that will cloud or will influence the voluntariness of a person. There are cases like persons from the mountain areas, and they will go to the cities, and you subject him to the frisk search. Automatically, that person will say yes. Why? Not because they voluntarily submit to the search, but because they are intimidated by you. And the intimidation could invalidate the warrantless search. So you have to be meticulous in utilizing this one. On the other hand, the police officer will also have the authority in terms of custom search. They are empowered by law to effect arrest and execute processes of courts when acting under the direction of the collector. They have the authority to conduct custom searches within the jurisdiction of the Bureau of Customs without the warrant of arrest. But then again, it should be within the plain view doctrine. For example, they will go to the port and then try to see or supervise the flow of the passengers, and it so happen that they see a person looking suspicious, and you have the probable cause to arrest the person or to search the person, then you can do so without the warrant. Number 6 is on stop and frisk or Terry searches. Police officers also have the power to stop and to perform frisk to a person. However, such action shall not be performed through irrational impulses, but through the existence of a reasonable suspicion. A stop and frisk is as defined as the act of police officer to stop a citizen on the street, interrogate him, and pat him for weapons or contraband. It should be noted that stop and frisk does not cover mere suspicion. Okay? So the suspicion is something that should establish probable cause. For example, while the person is walking having the jacket, you were able to pick or to see that the muzzle of the firearm was transparent. Seeing the muzzle of the firearm inserted at the waist of the person will give you the probable cause that this person might be performing a criminal act or might perform a criminal act. So you have the probable cause to do stop and frisk. But then again, if your suspicion does not validate a probable cause, do not do it. All right? Because that will be something that will be considered as illegal. The grounds of suspicion are reasonable when the person to be arrested is probably guilty of committing the offense based on actual facts, supported by circumstances sufficiently strong in themselves to create the probable cause of guilt of the person to be arrested. Like as I have said a while ago, you have suspicion that the person was carrying a firearm, and then by seeing or by observing the person, you happen to see by coincidence the muzzle of the firearm at the side waist of the person. That's already a probable cause for you to conduct a stop and frisk or Terry searches. But if the person is just walking, okay, he's just walking, like he's inside the mall, he's just walking, and you stop him to do frisk searches, that is unlawful, and you can be sued by doing so. Now you have to remember that under the law, police officers should not merely rely on a single suspicious circumstance. All right? Like you say a person wearing a jacket, and that is the only circumstance that you consider as suspicious. That is not the only circumstance that should be considered in establishing the probable cause. It should be more than one suspicious circumstance. Like say for example, number one suspicious circumstance, you see him observing other people, all right? See him observing other people. Number two, he is wearing a jacket with upon looking at the side waist or the waist of the person, it seems that he is carrying a firearm. Number three, he's about to approach another guy, and he look as if he is with him rage or anger. These circumstances would be enough for you to say that this person might commit a criminal act. But then again, if there is only one circumstance, like he is just trying to observe the people around, that circumstance is not enough to prove that there is a probable cause that exists. So therefore, do not make a stop and frisk searches. Okay? Do not perform this kind of search. But if in case, again, there are more than one innocent activity that would, based upon your inference, the person will commit, commit a criminal activity, then you can perform Terry searches. And take note also that in Terry searches, it should not be limited to outer clothing only for the purpose of detecting dangerous weapon. Okay, it should not be limited to the outer clothing. Like you just consider the jacket as your ground to do the Terry searches, that is invalid. And when you do Terry searches, cadets, when you will become a police officer, number one is you have to properly introduce yourself. Like you will say, I am Patrol Juan de la Cruz. And after you introduce yourself, you make inquiries. And then if possible, if the person is about to escape, you can restrain the individual, and you can check the latter for any contrabands or concealed weapons. Okay? So that's how stop and frisk or Terry searches should be conducted. So the job of a police officer is very sensitive in a sense that one mistake, guys, just one mistake, a criminal case or an administrative case can be filed against you. If you make an invalid search, an unlawful search can be filed against you. If you make an unlawful arrest can be filed against you. And these are something that are, requires punishment. Okay? So one wrong move, you can be punished also Okay, you can also become a perpetrator because of the wrong move, because you do not observe the guidelines of searches and arrest. So, lastly, in this video, we'll be talking about checkpoints, okay? Checkpoints that could also be connected on how searches should be made. So, in the Philippine National Police Handbook, which was edited in the year 2013, it reflects the composition of the checkpoint, okay? So, kailangan ni mag-observe. Una, team leader, the one who leads the checkpoint. Spotter is the one who will profile the vehicle. Meaning, the spotter will be the one to say nga, oh sir, suspicious na, pwede na ninyong gi-flag, pwede ninyong i-instruct to pull over. Kinsa ang responsibility? Spotter. Spokesperson, it could be the team leader or the member who is in charge with communicating with the motorist subject for checkpoint. But in reality right now, in the field or in the ground, usually the one who instruct the motorist to pull over will be the one to communicate the driver. Okay? Next, the investigation sub-team, who is in charge for the documentation and investigation of possible incidents that will arise during the checkpoint. The investigation sub-team will also be the one who is responsible in the issuance of TCT, or traffic citation ticket, or traffic violation report. You can also ask assistance from traffic officers to do this, to issue the traffic citation ticket. We also have the search arresting sub-team who is designed or who is designated to conduct the search, seizure, and arrest if necessary. So again, ang arrest ane or ang search ane is warrantless. Okay? We also have the security sub-team tasked to provide security in the checkpoint area, and the blocking or pursuing sub-team if in case there will be fleeing suspects or vehicle. Okay? So, those are the composition, or these are the composition of the checkpoint team. But in reality, in the ground, this is rarely observed, considering that there is few, right? There is limited manpower inside the police station, so sometimes the composition is not observed by in the conduct of checkpoint. Now, I will only discuss to you the salient guidelines in Rule 11.3 in the Philippine National Police Handbook as to how checkpoints should be conducted. Actually, there are so many guidelines, but I will only be focusing on the salient ones. Mobile checkpoints are authorized only when established in conjunction with ongoing police operations. Only officially marked vehicles with blinkers turned on, if available, shall be used in establishing mobile checkpoints. As I have said a while ago in the first discussion, a marked vehicle should be utilized. Okay? And the marked vehicle should be, the blinker of the marked vehicle should be turned on. Okay? Meaning the blinker is on while you are performing the checkpoint. And the checkpoint should be in conjunction with an ongoing police operation. For example, there is a gun ban or there is an escaped prisoner. So you can perform checkpoint. Checkpoints are established to enforce circulation control, measure laws, orders, and regulations. The use of mixed uniforms like GOA, field service uniforms, black fatigue in the conduct of checkpoint is strictly prohibited. So what does this mean? So it means that, as I have said in the previous discussion, during the basic operation like checkpoint, there should be no heterogeneous uniform. There should be similarity as to the wearing of uniform. Di kay ang uban ga GOA, di kay ang uban ga FSU, di kay ang uban ga black fatigue. So dapat GOA, General Office Uniform, General Office Uniforms tanan. Dili maglahi-lahi. So as much as possible, the area where the checkpoint shall be established must be properly lighted with noticeable signage bearing the name of the PNP unit and the participating organizations visibly displayed in the checkpoint site to prevent any apprehension from the public of the existing of the same. So meaning a signage should be placed unsay nakabutang ang head sa Philippine National Police nga gakandak sa checkpoint. So if it is municipality of Shaton who is making the checkpoint, the chief of police or the name of the chief of police of the municipality of Shaton should be put or should be written or should be reflected at the signage. As well as the place of the checkpoint should be properly lighted. It should not be dark when you do checkpoints during nighttime. Now, due courtesy must be accorded to the motorists, traders, and the commuters during the conduct of the checkpoint. The courtesy should come from the police officers. Alright? You have to be courteous. The spokesperson must greet the people subject for inspection, extend apology for inconvenience, appeal for understanding, and state the reasons of the operation. Upon completion, thank the person searched. So sa buti pasabot ani, dapat dili ka mag-inin stricto. Ikaw may police officer, ang imong buhaton, you will say good morning, you will say good afternoon, you will say good evening. And then you say, you apologize. You say, I am sorry for the inconvenience. We are doing the checkpoint in conjunction to this particular operation and we are appealing for your understanding. That should have been the case. Di kay pag-abot sa checkpoint, ikaw nga police officer, gidiritso nimo gayon nga imong lisensya, isog pa ka kaayo. Di pa ka kabalo mo ingong good morning, good afternoon. That is not the proper thing to do. That is not the standard as far as the Philippine National Police Handbook is concerned. Your job as a servant of the community is to extend courtesy, all right? Is to extend courtesy to the motorists, considering that these motorists have the right to travel. Okay? Have the right to travel. So, when you do checkpoint, kindly make a compliment, all right? You say, good morning, sir. Good afternoon. Good evening. Okay? And you apologize that you are doing this stuff. And you appeal for understanding. And once you are done with the search, you would like to say, you should say, thank you. Express your gratitude. Di kay, while doing the checkpoint, you pretend as if you are the master in the community. Do not do that, alright? You should not do that because you are considered as a servant, okay? As a servant. Your responsibility is to maintain peace and order. But in the maintenance of the peace and order, you make sure that the performance of the duty should be done with humility, with selfless service, and of course, moral ascendancy. Okay? So, for you cadets, if you will become a police officer, kindly, you can, please take heed of these guidelines because this is very important. Because once you greet a people, once you greet motorists, this is something that could boost public trust or confidence. But if you are very strict, like you rebuke, you reprimand, you raise your tone of your voice during the checkpoint, making it appear that as if you are a persona of higher authority, then that is something that could, make the community very apprehensive towards your operations. Okay? So I hope, as per observation, I hope this is something that could be changed. Second to the last, except in the actual commission of crime during checkpoints or in hot pursuit operation, the conduct of inspection of vehicle during routine checkpoint is limited again to visual search. What does this mean? Again, you have to abide on a plain view doctrine. Okay? Technically speaking, you are not allowed to open any U-box. Okay? You are not allowed to open any compartment of a motor vehicle because you do not have a warrant of arrest. Okay? It should be visual only. So if the driver of a motor vehicle, when you say open your U-box, this is very common. And the driver would say, sir, I will not open my U-box. Do not force the person to comply with your order. Why? Because that is his right. After all, you are just making a checkpoint, and a checkpoint should be based on should be in accordance with the plain view doctrine. Unless, if upon the plain sight, you see inadvertently a particular contraband or evidence. For example, a motor vehicle, and when you do plain view, or when you do plain view inspection, you see a suspected methamphetamine hydrochloride. So that could be something that will provide you a probable cause to make a search, okay? To make a warranted search. But if in case it is just a motorcycle and there are no contrabands that could be found in plain view, please do not instruct people or motorists to open their U-box, and do not force them to open their U-box, because that is their right not to open it, because you do not have the warrant of arrest, or the search warrant rather. Next is voluntary offers of cash or in kind from the traders, motorists passing the checkpoint should be absolutely refused, because the offer might be misconstrued as a bribe. Remember that we have bribery, and bribery is a crime. A police officer is not allowed to accept any form of bribe. For example, the driver would give him even just a petty cash, or the driver might give him a considerable amount of money, or anything that might be misconstrued as a bribe. So that should not be those kind of offerings or gratuities should be absolutely refused. So I would like to stop within this slide, and the other remaining basic operations will be discussed in the second video or in the second episode. So I hope you understand and you learn something from arrest, search, and seizure, as well as checkpoints. If you have comments or if you have questions that you want to be clarified with, there is a comment section below. You can post your questions there and I will answer you in due time. Thank you so much for watching. God bless you guys and stay safe.